During the course of the fight, Mr. Nagle was stabbed in the neck, and his spinal cord was severed. The defendant was chased from the scene, was seen at the scene with a knife, was chased from the scene by a number of young men, jumping, actually going through a couple of fences, and then the state police. DNA testing done on the knife found the defendant's DNA on the handle of the knife and the victim's on the blade of the knife. The defendant was left the area on that night, and along with his girlfriend went to the state of New Hampshire, and eventually turned himself in the state of New Hampshire on the 4th of July, and was brought back to Massachusetts. Mr. Nagle was taken to the Boston Medical Center. The defendant initially was charged with a number of charges, along with assault with intent to murder Mr. Nagle, and had a trial in this courtroom actually back in 2005, and was convicted by a jury of assault with intent to kill, the lesser included offense of assault with intent to murder, and was sentenced. And I believe he's serving the sentence now. He has, I believe, 2 years remaining on that sentence. In July of last year, Mr. Nagle passed away, and an autopsy was performed on him at the Office of the Chief Medical Examiner. An autopsy and the death was determined to be the result of a stab wound to the neck with injury to the spinal cord and complications from quadriplegia. And the medical examiner determined his death to be a homicide. Earlier this year, a grand jury heard evidence of the case and indicted Mr. Cirignano for 2nd-degree murder.
8 years between the time of the act on the person's death and any medical issues that arise. We've got a significant issue on a motion to dismiss or a motion to suggest that we've already got issue preclusion of collateral estoppel. The only difference is a death 8 years later. The facts are the facts. This is at best a manslaughter. And I think clearly there's an issue as to credit for the time that the person has already served for the act that he was convicted of. So all of these things understood, Judge. His background, the family support, the roots in the community, the facts of the case that clearly indicate that he was acting, and I think the jury verdict speaks volumes, in self-defense. He's got a pretty good case. Now, what does that mean when he's looking at another 2 years? And I know you're the Raj. I know that you're very efficient as far as pushing cases along. This case is going to be tried well within 2 years. So it may be, as you say...
I think the legal issue about whether he can be prosecuted at all could be tried or reached pretty quickly.
That's correct. Yes, I agree. But the point I'm getting at, Judge, is what is a reasonable bail? Even though the man's incarcerated, he's still entitled to a reasonable bail. It's not $250,000, Judge. I mean, you know from your prior experience as a judge, as well as experience as a judge, that this family has gone out, has obtained money, they've retained counsel, we've got expert witnesses, we've got an investigator, I'm in the process of reviewing all this information.
I don't know, how do you stand in discovery? Has anything been provided to Mr. Reddick?
I have grand jury minutes, and I'll provide it with Attorney Canoni had